our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, our topic is how seller financing of multifamily properties. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel and subscribe. You can find us on YouTube, Facebook, and Twitter. On each of those, you can find us at the handle @InRem Podcast. That's @InRem Podcast. Also, we want you to go to Apple or Spotify or any of the major podcast platforms. You can download a free version of the audio podcast, listen to it over the weekend. Sometimes that's easier than just watching a video. Go there, leave us a review, helps us out a ton. We appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is, what is a disclaimer deed and when should it be used? So basically, a disclaimer deed is a document that one spouse executes to disclaim their interest and any community property interest in real estate in favor of the spouse that's on title. And so basically, if in Arizona anyway, for community property purposes, any asset that's acquired during marriage is deemed to be community property, which means that both spouses have an ownership interest in the property. Now, one spouse can acquire assets through inheritance, through gift, or by bringing the asset into the marriage. And in that case, the asset, and real estate is an asset, the asset would not be community property, but would be that spouse's sole and separate property. However, there's a number of cases and laws out there as far as, what happens when you commingle separate property with community property. Does generally a portion of the separate property then becomes community property and the whole thing. And so most title companies are going to want a disclaimer deed, regardless of whether or not you can show a clear trail of ownership from prior to the marriage, into the marriage, trail of inheritance, a trail of a gift. Most title companies, though, are going to want a disclaimer deed because they don't know and can't establish or prove that the property was not used for some community purpose, or that community funds were not put into the property or used to pay expenses on the property. So normally the spouse that's not on title, the non-selling spouse, in order to effectively convey real estate, they're going to want a disclaimer deed. Or let's say that you are a married couple and one spouse is going to go on title to the property, maybe for lending purposes, and the lender is going to require that this be the sole and separate property of the spouse who they're providing the loan to, because the other spouse is not going to be the borrower for one reason or the other. In that case, they're going to require a disclaimer deed, which the spouse who's not going on title, who's not the borrower, is going to disclaim their interest in the property and any community property interest in that property. The effect of a disclaimer deed means that the spouse who is on title is the sole and separate owner of that property, that there's no community. And In the case of a divorce, now this isn't always true because once again, even after the disclaimer deed, you may have some commingling of community property, but generally in the case of a divorce, if there is a disclaimer deed out there, then the court would award the property to the spouse on title as their sole and separate property. Not 100% the case, but the presumption is that's what the court will do. So it's basically a deed that says, hey, I don't have any separate or sole and separate interest or community interest in this property that's owned by my spouse. However, this is only dealing with interest during the lifetime of the spouse on title. It is not a conveyance for inheritance purposes. So you're not disclaiming your right as a surviving spouse to inherit the property that was owned by your spouse as their sole and separate property if they're deceased. It only is during your lifetime. So if you do the disclaimer deed and your spouse passes away, that doesn't mean that you can't inherit that property. There's other rules which we won't get into as to what percentage or portion of that property you may or may not inherit. There's a number of factors that go into it, but that doesn't mean you're cut off from inheritance purposes. That simply means that during the lifetime of the spouses, that the property will be the sole and separate property of the spouse on title.
All right, Sean, thank you for the legal update. With that, a couple of announcements for you, the listener. Every Tuesday at 2:00 p.m. Arizona time, that's 2 p.m. Arizona time, we have the Creative Finance Collective. That is a live show with professionals from all over the country in the space of creative finance. We've got attorneys from Arizona, Texas, from Alabama to Georgia to Florida. We've had attorneys from really all over that focus and have a knowledge base within the area of creative finance, subject to transactions. We discuss those deals, the risks, the benefits, the rewards, what to watch out for, and how to work through those transactions. But mainly what we do is we take questions. We're there really to engage with the audience and take questions for an hour. So we're on as long as we get those questions. So if you have a question and want to work through an issue that you've seen, maybe you're wondering what it looks like from start to finish, maybe you're working through a problem and you're looking for a referral to a lawyer in your area, sometimes we can help out with that. Make sure to join us live. Post your questions. We're excited and look forward to engaging with you on that. Also, for today's episode, we're taking questions in the final 15 minutes of the episode. So if you're watching and you have a question, make sure to post it in the chat. We're monitoring the chat. We're taking note of those questions now. You don't have to wait to post the question. Then you can post the question now as you're thinking about it so you don't forget. So make sure to post those now. And if we get questions, we'll take those in the final 15 minutes. So with that, we're going to get into our topic today, and we're talking about seller financing of multifamily properties. And with us to discuss that is Colorado attorney William Bronchick. Bill, how are you?
I'm wonderful, gentlemen. Thank you for inviting me on the show.
Yeah, thanks so much for being with us. We appreciate it. So you've been on our show with us before, but for those who aren't familiar with you, why don't you tell us a little bit about your law practice there in Colorado and how you got into doing what you do?
Well, I've been a practicing real estate attorney for 34 years and originally from New York, licensed both New York and Colorado. I have also been a real estate investor for 32 of those 34 years because while attorneys make a good hourly rate, you still have to work to get it. So I realized I needed some passive income eventually. So I can only take clients that don't annoy me too much and pick and choose, which I love what I do as my law practice, but I don't do it 100% of the time because I have my properties that I have to deal with. And I write books and do seminars and do speaking and stuff like that. So depending on the day of the week, I'm in one of those three roles. And I've done a lot of transactions involving seller financing, residential and commercial over the years, upwards of, I don't know, I lost count, but I'm gonna take a stab and say somewhere between 1,800 and 2,000 transactions.
All right. Now I know that you maintain a pretty significant YouTube channel, which has a number of subscribers. Tell our listeners about that and how they can find that.
Yeah, it's just YouTube/Bronchick, my last name. We got about 61,000 subscribers, and there's hundreds of videos on there on creative finance and all kinds of other stuff involving real estate.
Yeah, really good stuff. And if you're interested, we've posted a link in the description of this live show to Bill's YouTube channel. Really good information. All right, Bill. So we're going to get into the topic at hand, and that's seller financing of multifamily properties. But as we get into it, I wanted to lay a little bit of groundwork because some of these definitions really do change from state to state or can change from state to state. So let's start with multifamily properties. In Colorado, what is a multifamily property, or what kind of property fits that definition?
Well, technically, a multifamily is anything more than one unit, but in different contexts, like for an appraisal purpose, for lending purposes, a multifamily is 5 units and up. So sometimes they're small multifamily, might be a 3 or 4 unit. Larger multifamily would be 5 and up. For example, Fannie Mae's residential financing is 1 to 4 family. They don't consider, even though they consider 4-family multifamily, it's not in their multifamily lending pool. And their appraisal rules are different for 5-family versus 4-family.
Okay. So for purposes of this discussion, I guess we're really just talking about anything over 1 door, right?
Yeah, that's right. It means more than one.
Yep. Yep. So how would you, given that we're talking about multifamily, we're talking about seller financing of multifamily. So let's break down what do we mean when we're saying and talking about seller financing?
When we have seller financing, that means the seller's not getting all cash at closing. A cash sale, which a lot of people confuse with the buyer bringing in all money, is when the seller receives all cash. And the buyer could come in with a loan and some cash, or an entire loan, or all cash. But in either case, the seller's walking out with all cash for his purchase price or for his equity. A seller finance is when the seller takes even $1 of that in the future after the closing. And typically that's going to be a promissory note with some payments on it over a significant number of years with interest. So what we're doing is we're taking out, in some cases, we're taking the lender completely out of the equation. So the seller, if he owns the property, let's say free and clear, the seller could take a down payment and a promissory note for his equity, and with payments on a promissory note with interest over a term of years, just like he would borrow from a lender, except the lender is the seller. In some cases, the buyer may borrow money from a lender for part of the purchase price, and the seller takes a note and usually a second lien against the property for the rest of the equity, plus some cash from the buyer.
So does the property have to be owned free and clear by the seller, or can the seller keep their existing loans in place, i.e. a subject to transaction, for it to be seller finance?
Well, either way, the definition I gave was if the seller receives any portion of his equity in payments after the closing, and that could be, he owns it free and clear. It could be, like you described, a wraparound where there's an existing loan staying in place, a subject to. If the seller is getting anything after the closing, then it's a seller finance by definition.
What are some of the advantages for a seller to carry back financing on a multifamily property in particular? Why would they do it?
Huge advantages for the seller. The biggest one would be the tax savings or the tax deferment on the capital gains. So if you've owned the property for a number of years and you're going to make, let's say, $500,000 or $1 million or more in gain that you'd normally have to pay the following spring to the IRS as a capital gains tax, if you're taking your payments over time on your equity, you pay your taxes over time as well. So if you take, let's say, a 30-year loan from the buyer, a 30-year note, then each year you're receiving a little bit of principal and you're paying a little bit of tax on that principal each year. Now, on the interest portion, it's just like any other interest income, but on the principal portion, the capital gain part, you're spreading your liability out over 20, 30 years, however long you're going to carry the payments for. And of course, you ask any taxpayer, would they rather pay it all now or pay it over 30 years? The time value of money, they'd rather pay it later than now. And there's no difference in the amount, by the way, in terms of the principal, whether you pay the taxes on $1 million now or the $1 million over 30 years. Of course, it makes sense to pay it over 30 years because they're not adding additional tax onto that. It's the same number.
Well, what about, and there's talk about capital gains percentages going up, especially, the end of, I believe, 2025. So what if the percentages go up, is the seller going to be stuck in, that type of increase if they do a seller carry?
Well, what I described is what the IRS calls an installment sale. As you receive it, you pay tax on it. So the only difference is the rate you would pay as you receive it, 21% or 20% versus whatever rate they're proposing. I don't think that's a reality. I know Harris has proposed 30-something%, but whoever wins this election, it's going to be a real thin margin in Congress. And that is what you would call, not a run-of-the-mill tax increase. That's a pretty extremist thing, to raise the capital gains rate on not just on real estate, but on stock, on any other assets in business that you've held a long time or investment. That would be extreme. Maybe, if Harris wins, she gets it up to 25 or 28% for people in the higher tax brackets. That's possible.
Yeah. So on multifamily properties, a lot of times, a seller is selling because of the fact that they're just tired of dealing with tenants. They're tired of dealing with maintenance. Is that a good, basically a prime candidate for seller financing, meaning they're still getting money every month. They just aren't having to do anything for it, really.
Yeah, and that's part of the sales pitch that you as the buyer should be prepared to give to a seller. You can't just go out there and say, hey, will you carry payments, or will you do seller financing, without explaining the benefit? Because most sellers will just say outright no, because they don't know or they're confused. So you have to sell them on the benefit. The benefit being paying taxes later. The benefit being you could still get some income without dealing with the headache of the management. Another benefit is they can usually command a higher price than if they demand all cash. Because if I, as an investor, have to pay all cash, meaning use my own money or borrow from a lender at high interest rates, I want a pretty big discount on the price. If the seller is willing to carry payments, I'll give them a better price as long as I get my terms, which is going to be, payments over a longer period of time with less down that I would normally have to put up if I went to borrow from a commercial bank, and usually at a lower interest rate.
Bill, what about the risks to the seller? Because there's, with everything that there's benefits, there are some corresponding risks.
Sure.
Let's talk about those.
Yeah, I mean, the seller, if the seller carries back a loan, a note, and they're going to be secured with either a first or a second lien against the property, like any other lender, if the borrower, in this case the buyer, defaults on payments, the seller's going to have to go through a legal proceeding to get the property back. And so if you're the seller, from the seller's perspective, you want a buyer who's experienced, who has done the math and understands the dynamics of the transaction, and hopefully puts enough money down as a down payment that they have skin in the game where they're not just going to walk away if it goes bad.
So let's flip over to the buyer side of this thing. So we've been talking about the seller. From the buyer's perspective, talk to us about the benefits there to the buyer.
Well, the flip side for the buyer is the buyer doesn't have to put usually as much down payment down. The minimum you're going to have to put down for a commercial loan is 20%, often 30%. And most multifamily loans are not 30-year fixed. They're going to be 15, 20, 25-year term. And the shorter the term, the higher your monthly expense payment. So we want to get a longer term, 30 years or maybe even 35 years if we can get it. Also, the buyer might have to put less down and doesn't have to qualify, doesn't have to pay, 1 point or 2 points origination fee on a $4 million loan. That's a lot of dough. If you're dealing directly with the seller, you're not going to probably pay that. You'll maybe give the seller a little more down instead, which is going to lower your payment. And in addition, the buyer can acquire properties in a corporate entity. Unless the seller insists on a personal guarantee, you can get away with less liability. Whereas most lenders, if it's under 10 million, they're going to require a personal guarantee on a note that is signed by a corporate entity. And finally, it's something that doesn't require really that you qualify for. It's a pretty stringent qualification process to get a commercial loan, especially in the multi-millions. You have to have a certain net worth. You have to have a certain amount of reserves. It's whatever you negotiate with the seller.
Yeah, that's what one question I was going to ask there was an underwriting question. The in a conventional transaction, the commercial underwriting is pretty extensive. In your experience, are sellers in a seller finance transaction as stringent or even close to as stringent in their requirements and underwriting?
No, not if they're motivated. That is,
Yeah.
if we're dealing with a motivated seller like you described, who's just sick of running it and wants the cash flow but doesn't want to deal with the maintenance, they've got some motivation there. If it's someone who wants top dollar and wants, if he's willing to carry it, is very, very careful or very, very stringent about his qualifications, it could be as bad as dealing with a commercial lender. But that I find that not to be the case, and especially I mentioned, 5 family is where the commercial lending starts. 1 to 4 family, Fannie Mae will do residential, and then 5 family and up is commercial. When you get in that sweet spot between about 5 and 15 units, it depends on what market we're talking about. But if we're in a cheaper market where that's not that big of a loan, maybe a 10-unit apartment building that's $150,000 a unit, so it's $1.5 million loan or $1.5 million purchase price, 500 down million loan. That's not a big loan for most banks, and therefore there's not a lot of banks who want to do it, and therefore there's not a lot of good loans. And that being the case, fewer buyers can get that money, and it makes it harder for the seller to sell. So sellers know this, or at least their broker should inform them that, hey, in that sweet spot of 5 to 15 units, the exception of maybe being California where that's $10 million, you're going to have to offer some incentive to get the price you're looking for and sell it quickly. And that is going to probably be seller financing to make it easy for a buyer who doesn't have to go to a commercial lender and get a lousy loan, maybe 15-year term, an adjustable rate loan, a 5-year balloon, something that's not really desirable for the buyer.
So what about the risk to the buyer? I mean, the benefits sound like they really stack up for the buyer
Right.
here when you can avoid some of that. Are there risks, though, to the buyer in this kind of deal?
Oh, sure. A buyer shouldn't be chasing every deal that the seller's offering seller financing, because sellers who are savvy know that they're going to be charging a premium price and sometimes more than the property's worth. So just because you can get a property, I say, for no money down or seller financing with a low down payment, it's not always a great deal. Or even a subject to, it's not always a great deal. You still have to do the math. You still have to do the numbers and make sure it works at the price the seller is asking for, and according to the interest rate that you negotiated, and all the other factors involved. Just because the deal is seller financing doesn't always mean it's a good deal for the buyer.
So talk to us about, and you've mentioned some of the difference in conventional financing, but in setting up a seller financing transaction, what are the differences you're going to be looking at between kind of seller financing on just a single family residence versus a multifamily? What makes it unique? Are there some unique things that you're looking at, watching out for, and setting that up?
Well, there's not that much of a difference, actually. You have a promissory note, and then you have a lien, which is going to be, depending what state you're in, accomplished with a mortgage document or a deed of trust. The only major difference between a commercial deed of trust and a residential deed of trust is usually a commercial deed of trust has what's called an assignment of rents, which is the ability for the lender, if the borrower defaults, to step in and collect payments. And maybe in the process may have to get a court to appoint a receiver while they're foreclosing the property. Whereas in residential, if you're a landlord, you're still collecting rents and not paying your mortgage, very common. Whereas if you're dealing with a 50-unit property, the time between foreclosure starts and ends, that could be hundreds of thousands of dollars that the borrower is pocketing and not making payments, and the lender will want to get those in the meantime while they're foreclosing the property. So that's one of the main differences. The promissory note tends to be a little more detailed in a commercial transaction in terms of what is considered a default. And usually there's another document called a loan agreement, which it contains additional promises of the borrower. Like if it turns out that the borrower lied on his loan application, the lender can call the loan due. Or if the borrower fails to do X, Y, and Z in addition to the promises in the note, then the lender can enforce the loan and call it due. So it's huge, but again, that's usually dealing with commercial banks. When you're dealing between individual seller and buyer, it's whatever documents they're willing to accept.
So on multifamily properties, let's say we're a 15-unit apartment complex. What are your typical loan terms that you see a seller willing to negotiate? I mean, obviously it's all subject to negotiation, but what kind of loan terms are you looking? I mean, are sellers driving a hard bargain and 5-year balloons, or are they letting it amortize over 30 years? What's the interest rate you're looking at? That type of thing.
Well, I'll give you the lawyer answer, I guess. It depends. It depends how motivated the seller is and what the seller's goals are. If the seller, a lot of sellers who are in their 75, 80 years old, they think they can't carry a 30-year note, so they want it ballooned in 5 years, presumably before they die, so they can leave cash to their family. But when you explain to them, well, look, there's no need for that, because first you're going to get taxed like crazy in 5 years, because once they receive that balloon payment, all of the deferment is over. The rest of the loan is paid, and it's all taxed that year for the capital gain. Instead, let it pass through your estate, and I'll make payments to your spouse or your kids or your grandkids, and for the rest of the 30 years.
So let's talk about transaction structure and setting this up. Now, you've referred to this a number of times throughout some of our questions and in ways to set this up in seller financing. Pretty classic way is to mimic the conventional loan, which is the note and deed of trust, just like any normal lender, with the right to, if it's a non-judicial foreclosure state, the ability to non-judicially foreclose on a deed of trust. But that's not the only transaction structure. We like to ask this because states are a little bit different in what they'll allow and what they recognize. We have the land contract here, the agreement for sale, contract for deed, whatever you like to call it. Why don't you talk to us a little bit about the different kind of transaction structure opportunities that there are, different ways that you've seen set it up over there in Colorado, and what are kind of the advantages and disadvantages to them?
Yeah, a contract for deed, also known as a land contract or bond for title, depending what state you're in, is pretty risky for a buyer on a big commercial deal, I think. Usually on a single family home or duplex, I'd allow my client as the buyer to sign one of those, because there's so many risks for the buyer. It's definitely favors more the seller, because in a lot of states there's a procedure called a forfeiture, which allows the seller to get the property back faster than a foreclosure, but a little slower than an eviction. And as the buyer, if that's my client, I'm going to say, no, you want the foreclosure benefit. You want the time period for them to go through it, not a quick kick you out in a couple of months if you default on one payment. So that's a risk to my client, the buyer. Also, this is the big one. A lot of people don't know this, that if the seller files for bankruptcy, and it's not likely so much in a commercial, but more often in a residential, but the seller could be extended. And if they file for bankruptcy protection, then the trustee in the bankruptcy has the authority to cancel all what we call executory, which just means incomplete contracts. And a land contract or contract for deed is an incomplete contract. So they can cancel the transaction, and you're left holding the bag. You're not getting the title to the property at the end of the transaction like you were supposed to on a contract for deed. So that's really risky for a borrower. And the third thing is the seller can end up with liens on the property that attach before the contract is up, because the way a contract for deed works is you make payments just like on a mortgage, but you don't get the deed to the property until you pay it off to the seller. And if an IRS lien or a judgment attaches to the property in the interim, that can foul things up pretty bad for you. So, selling as representing a seller, I'd say fine. But buyers, I caution them whether they should do this. I mean, I guess if it's a good enough deal, I've done it. But the seller in that case was a PhD, MD doctor who was just really motivated because he was an out-of-state landlord. But he wasn't going to walk away and file bankruptcy anytime soon. And I actually ended up with a problem because he died. And then when I went to get the deed and pay it off, his son, the executor of the estate, said, no, I don't like that deal. I'm renegotiating. Tried to screw me on the deal, which is another thing that can happen. The seller could die, disappear, whatever, or just outright refuse to deed the property over to you at the end. So there are risks, but I'm not saying you should never do it as a buyer. it's a risk reward. If the profit is good enough, if it's a smoking deal, you may want to take a chance, especially if it's only like, maybe a fourplex where you're putting up 50 or 100 grand as opposed to $1 million on a big multi-unit.
What about subject to seller financing? So wraps. What are the differences between, and let's talk like more than 5 units, 15 units, for example. What's going to be the differences between the loan terms on that type of multifamily and say a residential loan?
Well, if the seller has a really good loan on the property that they got, maybe it's a Freddie Mac. Freddie Mac has some 3.5, 3.8% loans out there. I came really close to getting one, by the way, and just assuming it, not taking it subject to, but assuming it. And the process was pretty easy, but they wouldn't allow the seller to take a second lien against the property. That was just in their rules. But Freddie Mac and FHA and some lenders, you could be looking at a 4 or 5% loan, which in today's market is really good, especially if it's fixed. So if you could take a property subject to a 15 unit subject to the existing loan, and then give the seller some cash for their equity, or cash and maybe a promissory note secured as a second lien for payments, that would be really favorable for you as the buyer to do so, because you're not going to get a 5% loan for a commercial property in this market, and certainly not 30-year fixed, and certainly not one without a balloon real easily.
Now, you mentioned in the transaction that didn't happen because you couldn't put the second on the property, that you were actually trying to assume it. Do you recommend on multifamily that you actually go and try to, put the assumption in place, or can you do a wrap without that assumption approval on a multifamily?
Well, we asked, but the seller said no. He said, no, we're not doing this without So, but it was a 3.8% 30-year fixed loan that was already 6 years into it. So I was like,
right,
this is a really good loan. And the process wasn't that hard to assume it. And it was only 60% loan to value. So it wasn't a risk for me to assume it, because if it goes bad, the chances of the foreclosure not yielding 60% loan to value out of the sale were pretty slim for me personally. Now, the note I was going to give the seller for the rest of the equity was going to have, no recourse against me personally, no personal guarantee. So that I wasn't worried about. But remember, if you assume a loan, you're on the hook. And if there's not a lot of equity and the property goes to foreclosure, you could end up with a personal liability.
What about the servicers on these types of loans? You mentioned Freddie Mac. Do you see a lot of like smaller community banks that are going to, maybe monitor their portfolio a little bit more than, say, a securitized loan servicer?
Yeah. What I was going to say, if you're going to take a property subject to, or you're going to buy it on a wrap, or you buy it on a contract for deed, and there's another way to do it, which if we have time, I'll get into, which is buying it through the LLC. If the seller's loan has an annual auditing requirement of their lender, and the lender audits their loan and sees, wait a minute, your tax return says you sold it, and you didn't pay off the loan, that's a problem. And that's usually not the case with smaller loans, but bigger loans, a lot of times lenders have an annual financial audit of the borrower. And if they produce tax returns that show the property's been sold, or they don't have any financials for the last year for the property, then the lender might balk at that.
So talk to us about this LLC transaction.
Yeah.
So third option. If
a seller owns a multi-unit in an LLC that was only set up just for that deal, and it's doesn't own anything else, and it hasn't been a long period of time, so you're not worried about maybe potentially inheriting a lot of liabilities, and the seller is the sole owner, so it's single member, so it's disregarded for taxes, you could transfer the membership of the LLC from seller to you, and then basically take it subject to through the back door of not transferring the deed to the property, but transferring the ownership of the LLC that owns the property. Now, again, if there's an annual audit requirement, that's not going to work. And it probably does trigger a due on sale, because most commercial loans will say if the borrower is an entity and you transfer more than 20 or 25% of the membership, then that gives them the right to call the loan. But how would they know?
Right. Yeah. In especially if the LLC was set up in a state where you don't have to report ownership to the actual state, and it's governed by an operating agreement.
Right.
Well, let's break that down a little bit. So let's say that I want to go in and I want to acquire a membership interest in the LLC. Am I doing that with cash, where I'm cashing out the seller, or can we do some type of seller financing for me to buy that membership interest?
Either one, both. It depends on how much equity is in the deal. If the seller wants a bunch of cash and you don't have it, you could give them some cash and then maybe a promissory note, and he only holds back the membership interest, like part of the membership interest. Let me give you a deal I did like that, so you understand what I'm talking about.
Yeah.
We did a deal where it was a couple of hundred units of apartments. It was 3 apartment buildings. And the seller owned it in a single member LLC, all 3 properties. And he wanted out. He was in a divorce, and, he was really motivated. So, we paid $4.8 million approximately, with, 600 down at closing, taking subject to, a 3.8 loan, which was a really good interest rate. And then the other 400,000 was to be paid in 2 years. And so that was like the seller financing part. That was like the seller carry back the 400. So the seller's attorney and I, we looked at, and this bank was looking for an excuse to call this loan. They didn't want it in their portfolio, so we had to be careful. So we looked at the mortgage, and the mortgage said, if you transfer 25% or more of the membership, then we can call the note. I said, oh, so why don't we transfer 24.99%? And then when we give you the 400, you can transfer the other 74.1% or 1%. And we actually showed it to the lender, and they went fine. We got their approval. And so it worked out just fine. So you can do some financing, and instead of securing it with a lien on the property, the seller secured it by holding back part of the membership interest.
Yeah. So basically you had an option to, or a requirement actually to buy out their, almost like an agreement for sale, but for a membership interest.
Right. It was like, I guess it wasn't a contract for deed. It was a contract for membership.
Yeah, exactly. Yeah. Yeah. Oh, very cool. Yeah. That's, now internally, obviously you guys want to be treated as the owners. So presumably there was partnership taxation, and you could do unequal distributions, or
that was my first thought. Is the IRS going to treat this as a partnership between the seller and I? And we got a big tax firm to basically write us an opinion letter saying, no, substance over form. The seller's holding back the 74% or 75% as collateral, even though he still has the membership. He's not really a member. So you could claim it as all the buyer's property.
Oh, yeah. So you're not even having to pay profit distributions.
Nope.
On that 74%.
I think it makes logical sense. I mean, on a contract for deed, the seller holds back the title, but he's not the owner of the taxes. The buyer on the contract is the owner.
Yeah, so it's a contract for deed, but for an LLC membership. That's awesome.
Yeah, essentially.
That's really cool.
Yeah. So how do they handle that conveyance? Is at the beginning, the assignment, just an assignment of 24.99 with the obligation to assign or distribute the rest at the end by assignment or some other instrument?
Exactly.
Interesting. Very cool. So we've had you on before, and we've talked a lot in the past with you about land trusts. And do you like to incorporate land trust? Do you incorporate land trust when you think it's appropriate in multifamily seller financing?
If it's a 1 to 4 family, I would. because those are typical Fannie Freddie loans, which have an exemption allowed for the due on sale. So people use a land trust for a number of reasons, but not the least of which is, okay, there's an exemption under federal law where a lender can't enforce a due on sale if you put it in a trust. But when you assign the trust ownership to the buyer, it does trigger it, but they wouldn't know, and the lender probably assumes the seller is doing some estate planning because he put it in a trust. That's why people do it. Let's face it. There's no such exemption for commercial properties over 4-family. So if you put it in a land trust with a 15 unit, the lender can just call it right to immediately due. There's no exemption for that. No, they probably won't.
So, yeah,
probably won't, but.
Right. So you're talking the Garn St. Germain Act, which only applies to residential property and has, I think, 9 exemptions.
Right.
One of which is putting where the seller for estate planning purposes puts the property in the trust. So, but that does not apply to commercial property.
No.
Right.
So,
which is why you couldn't do your second as well on that one, because the bank can write the rules on that.
Right.
Because Garn St. Germain would. Okay. Very, very interesting.
So talk to us about planning through additional types of assets or contracts that are acquired as part of a multifamily purchase. The first big one that comes to my mind is the leases that are in place. How should a buyer be working through that and transactionally be thinking about the leases?
So the buyer, during the due diligence period of the contract, wants to look at the existing leases. I mean, who's on a lease, who's on a month-to-month, what do the leases say? Are there automatic raises? Are there things in there that are, good or bad? And as well, if you can, getting some of the tenant files. You might be violating a few credit laws by the seller giving those to you prior to closing. I mean, they would give it to presumably the tenant files after the closing. But see how qualified these tenants are, because a lot of landlords will shove a bunch of unqualified people in there and say, look, it's fully occupied, and then when you get it, they'll default. That's not good. So you want to look at like how long they've been there, what they've been paying, have they been paying on time? Look at the rent roll and the rent history, and they could give you that, but I don't think they can give you the credit reports from the tenants when they applied. But certainly, if someone's been there for 3 or 4 years and been paying, and if they're there for 3 or 4 years, that means they've probably been paying. You'd be all right. But you want to make sure that you review the leases, you review the rent rolls, you review the income and expense history. And that anything, maybe even have a tax professional or some sort of professional look over those to see if there's any red flags. Are they overcharging and underqualifying tenants? Or maybe they're overqualifying and under renting the property, which is a good thing for you as the buyer. It means you can raise rents in the future. But the first one is scary, because if they put in unqualified tenants at a higher rent, you're getting something that's sort of a ticking time bomb.
Mm-hmm. Well, and we're kind of getting, without using the term, but we're kind of getting into talking about this process of due diligence.
Mm-hmm.
And in multifamily, dealing with tenants is a new element that has to be planned for. What kind of time period do you like to build in for purposes of due diligence to appropriately work through these issues that you're talking about, the tenant issues and anything else unique to the due diligence process of multifamily?
Well, on something like we mentioned, the 15 unit, I don't think it would take more than a month or two to do your due diligence, unless you wanted to do, if you have to do an appraisal, if you have to do a commercial inspection, which is very pricey. It's not like $400 like it is on a single family, folks. It's pricey. And if you end up not buying the property and you fork out thousands of dollars, that's an ouch. So you want to at least walk the property yourself first and make sure it's really worth paying thousands of dollars to have an engineer, go through this and inspect it. So if 15 units, you could do that in 2 months. The only exception I would say is if there's a potential environmental issue and you have to get an environmental phase 1 or even a phase 2, possibly, that could take many months to get done. And a phase one environmental is a sort of preliminary inspection. The red flags are: did they ever have underground fuel tanks? Is it near, within 100 yards of a dry cleaner, an oil change station, a gas station, or anything environmentally hazardous? And if anything comes up on the phase one environmental, then you may have to get a phase two, which is expensive and time consuming and so forth.
What about, obviously you mentioned the tenants that are in there and their ability to pay is, of course, of huge economic importance to the buyer. Can't be understated. But what about reviewing of the leases themselves? Not every contract is created equal.
Yes.
And are there particular provisions or the lack thereof that you would be looking for in the tenant leases?
Oh, sure. I want to see how much security deposit they gave, and then how much security deposit they have. Because sometimes landlords let tenants use some of their security deposit, let's say if they were late one month and never got it replenished. So that's important. We want to make sure that it doesn't automatically renew for another year. That would be bad if the rent doesn't go up, or if it's an undesirable tenant. So we want to look at their lease form and see what they have for the people on leases. Remember, when you buy a property, you can't throw out the tenants who are on a lease. You're taking it subject to the leases that are there. So if everyone's on a month to month, it's easier, but it also depends on what your state law says. In some states like mine, it's very hard to not renew someone. Now they have this law that says you can't arbitrarily non-renew somebody. Just like, I don't like you anymore, I don't want to renew you. Well, you have to have specific reasons why you can't renew them. Otherwise, you have to renew them, which is bad. Again, that just drives more landlords out of the business. Fewer properties to rent, higher rents, and they're not accomplishing what they're trying to do, the government. But, the government usually doesn't.
That's really interesting. I didn't realize that about Colorado. So what would be an example of specific reasons that you have to show? I mean, you're
going to sell the property.
Okay.
And you still have to, in some cases, pay the tenant up to 2 months rent for them to leave. If they had multiple violations during the term, that's another reason. And there's a laundry list, but it's not real long.
I mean, I guess one of them could be if they don't want to, unless your lease prohibits it, but the ability to increase rent,
Yes.
each year, and then they just don't want to pay that. That might be one. But boy, it makes you wonder why you even bother have a termination clause in the lease to begin with. You have to have. It sounds like you have to have cause, basically.
Yes, you have to have cause to non-renew a lease. California has the same thing. They've had that for years.
Wow.
Well, so can you, as a subterfuge, raise rent so that the tenant's not going to be able to pay it and just be like, oh.
But
so you could say, hey,
limits on how much you can raise the rent in that case to try to do what you're saying, which is, okay, you want to stay? It's going to be double. No, you can't do that.
Okay. So there has to be some reasonable basis for the rental increase.
Yeah. No, you don't need a reasonable basis for the rent increase, but you can't double it as a reason to get them out, and all the other units you're charging less.
Okay. Yeah. So if somebody comes in and looks at it and says, wait a minute, you weren't going to really charge them double, you just wanted them out. That's basically violating the law.
Right. Yeah, that's right.
Okay.
Well, I like that. This kind of leads us into our next question, but this is a classic mistake I could see an out-of-state investor making. The cowboy that comes in and says, man, I've heard Colorado's great. We've got some great deals. We're going to come in, and they don't even look at the landlord-tenant eviction laws or renewal laws, and then you get
And it's not, it was, when I came in 93, it was pretty much the Wild West. You could do pretty much anything. Now, even though they've passed a lot of legislation against landlords, it's still fairly easy to get a tenant out compared to LA or New York or Illinois, Chicago. It doesn't take that long to get somebody out. But, instead of a 3-day notice to that you haven't paid rent or leave, now it's a 10-day notice. That's a big jump. And then you're not allowed to charge late fees until the 8th. And it can only be 5% and one time. So we used to say, if you haven't paid by the 3rd, it's, $100 plus X dollars per day. Can't do that anymore.
Interesting. So what in your mind are the biggest mistakes buyers are making in multifamily transactions?
Yeah, I would say taking the word of the listing broker or the seller on the expenses. That's the biggest mistake I make. Sellers have these, and listing brokers prepare these pro formas where it says like, well, it's under market rent 20% now. They all say that, don't they? And so here's the analysis for next year with the rents at market. Well, you can't raise somebody 20% in a year. Half of them will leave. So you have to bump them up slowly over a few years. Otherwise, you're going to lose half your tenants. So that is a false representation in my mind that the listing broker or the seller is making. Another thing is there's no line item in the expenses for, say, property management. And the listing broker seller says, well, I manage it myself. I'm like, well, good for you. That's a job. I don't want that job. So it is standard practice to include, let's say about 10% of the gross rents as a line item expense when it's doing the evaluation. Because certainly I would not recommend that any investor manage their own multi-unit. That is a job. I mean, I don't care if you have 10 single families. You get one 10-plex, that's like having 50 single families. It's a whole nother ball of wax.
Good information. Well, Bill, this has been awesome. We really appreciate you taking the time and to talk with us. Tell our listeners one more time how they can find and connect with you.
Yeah. My website for my legal stuff in Colorado is bronchicklaw.com. And I also have another website for real estate information and investing courses and stuff at legalwiz.com.
All right. Well, Bill, again, we thank you so much for being with us. We enjoyed it. Let's do it again sometime.
Great. Thanks, guys.
All right. You have a good one. With that, everybody, that is our show. Thanks for joining us. Make sure to join us today at 2 p.m. for the Creative Finance Collective, and we'll see you next time.
Have a good day, everyone.